CEO of the New York Society of Association Executives. Every Friday, almost every Friday, we hold these engagement lounges. We have a new topic every week. In addition to the engagement lounges, we have lots of other activities and programs, and I'll tell you about some of them later because we have some really great ones coming up. But I want to thank you for coming this morning. This morning, we are going to be talking about a very exciting topic, getting back to work. And not that we haven't been working in the last 4 months, but I'm talking about in the office, right? So we're going to address post-COVID-19 workplace challenges. And just have to say on the side, I love when I hear the post-COVID because I'm thinking, we're not post-COVID yet, okay? So let's talk about in the middle of COVID-19, we're getting back to work. So we're going to talk about that today. And we have an expert in the room. We do. And I want to tell you a little bit about the expert. But first, I want to just remind you of the format of today. Although we have experts in the room, and by the way, you are all experts too, because I know some of you have gotten back to work. This is an open format. We are encouraging you to be interactive, for you to ask questions, for you to answer, for you to share what you're doing. And then that's how we are successful in our engagement lounges every week. Okay, so let me introduce you to our expert in the room today, and that's Andrew Kimler. You'll see on the screen, Andrew Kimler is waving right now. Andy, as we're going to know him today, he's a partner in the law firm of Vishnick, McGovern, Malizia, and they have locations on Long Island, New York City, and New Jersey. And he heads up the employment law, commercial litigation, and alternative dispute resolution practices. And he's also a key member of the LGBTQ representation practice. Andy regularly writes and lectures on unemployment law matters, which is what we're going to talk about today. And for those of you that are on the island, or in Connecticut, I think it is, and News 12, you may have even seen Andy on television last week talking about this very subject. That's how much we are so excited to have him in the room with us today. So we're going to encourage everyone to share, and Andy's going to throw out some questions. I'll be throwing out some questions. We have a bunch that we received in advance, and I thank you for that. So let's get started. I just want to ask Andy, on a high level, just to frame it, what are you hearing from your clients? What is probably the greatest concern about opening up our offices and asking our employees to get back to work? So I'm going to turn it over to you, Andy.
Well, good morning, everybody. First of all, nice to meet you all. This has been what a long, strange trip this has been for all of us. In this new world, my own office, many offices are besieged with a lot of concerns and questions concerning what can we say and do? What can we ask employees? What can we require of them? How do we deal with COVID-related issues that pop up in the workplace? And how do we deal with the school-related issues that are popping up all over the place by reason of COVID-related shutdowns? Those are the areas that I see that are quite prevalent amongst our clients and our own office as well. Let me do this. I want to touch upon a few issues, both in the context of what are the protections and concerns of employees and employers in terms of the COVID situation. And to start off with, there is a tremendous amount of concern in terms of what can I, as an employer, do when people come to me and say, I'm afraid, I don't want to come to work. Can I work from home? I have anxieties and fears. What is required of the employer under those circumstances? Generally speaking, it's in the best interest of everybody, obviously, to sit down and try to work something out that makes everybody feel comfortable. However, the bottom line is, under the law, and the EEOC has come out very recently with guidelines regarding this, an employee does not have a lawful right to refuse to come to work based upon let's call it general fears and anxieties. Unfortunately, if an employee refuses to come to work because they're just worried about commutation or that they could be exposed to something when they come to work, they can nevertheless be terminated. And that's just the facts of life. However, there are situations that arise whereby an employee might be entitled to an accommodation. And the accommodation that frequently arises in that context is teleworking, remote working, which many of us were doing anyhow over the past few months. And that frequently arises in the context of employees that have a serious medical condition. And they're afforded various protections under the American with Disability Act, as well as various laws amongst the states. So if a person has a significant medical condition that puts them in a high risk group in the context of the coronavirus, they are entitled to request and seek some sort of an accommodation. Again, that frequently arises in the context of people working from home. Can I work from home? Can I do this job remote? Because coming to work may expose me to the virus, and I have, let's say, a compromised immune system. I dealt with this recently with an individual who had an organ transplant, and he did not want to come to work because his immune system was compromised by reason of that transplant. And thus, he fell into the high risk group of individuals that should be accommodated under those circumstances. How do we do it? Well, basically, it's a dance. The courts have called it a dance. You go back and forth, you try to accommodate each other, and you see if you can work something out to accommodate the needs of an employee who has a serious medical condition in a manner that doesn't create an undue burden to the employer. You know, and that's always a component of this give and take, this dance that the courts and the EEOC refer to. But the bottom line is people that have a serious medical condition or pregnant employees who fall into that category are entitled to seek and receive some sort of an accommodation. Again, generally speaking, that involves requests to work remote.
Thank you. Let me just stop Andy there. And I just am curious to ask this question. We're about 42 in the room right now. By using the chat feature, I would love to find out how many of us have already opened up our offices, even if it's a percentage of our employees. Write yes in the chat. I'm curious if we're all waiting to open up. Start writing yes in the, okay. Start writing yes in the chat. I'm curious how many of us have already started. Okay, that's interesting. And that way, Andy, we'll see that as well. So there's a lot of yeses. Okay, Andy, so we have some people here that have opened up. So I'm curious, let's get it on gallery view. I don't know if you all can click gallery view so we can see our faces again. Those of you that have opened up, can you unmute? Can somebody unmute and tell us, with what Andy was just saying, has that hit us yet? Has that resonated? Do we have any employees that came to us to say, I'm not sure I'm going to be coming in? Has that happened to any of us yet?
Yes.
Who was that?
That was Mary Jane.
Oh, hey, yeah, Mary Jane.
Good morning, everyone. I have one employee who's young, who still lives at home, and both her parents have compromised immune systems. And so I've been sending her work through the mail, like we have change of address and things like that, or scanning it. And then we're giving her other special projects that she can do to work from home. Because we have, we still have Zoom meetings twice a week with the staff. And so we kind of hear where people are, and everyone's on a staggered schedule.
That's a great example. of somebody who's accommodating, working with the employee and showing flexibility without specifically concerning yourself with a particular law, because that's the right way to approach it. You want to maintain employee morale. You want to show others that you're sensitive to their needs. I mean, that's very important. Sometimes people have to forget about the laws and figure out, how do I retain the services of an employee? How do I maintain and boost employee morale? Being flexible and showing that kind of sensitivity is critical, especially now, as tough as it may be.
Yeah.
Hey, Ali, this is Amish. We've opened up our outer offices, and we're going to be opening up the city office, I think, August 3rd. And, a couple of questions for Andy. It seems like the protocols these, various companies are putting it in place, it seems like we're all over the map. It almost seems like people are just making up things as we're going along. So, I'd like to hear his input on that. And then we had one situation where we hired an individual to be a tax administrator, so that clearly that person would need to be in the office. And then when that individual started, I guess she started complaining that, somebody came over to her desk without any gloves, or they may not have had a mask on and things, and then they wanted to request to work from home. And then when we said, no, you were hired to be in the office, that's what your role would be, I guess she resigned. But I guess from what I heard you saying correctly, theoretically, we could have terminated her without any legal backlash.
Yeah, I mean, what a mess, right? You have certain requirements that are imposed. Are you in New York State?
Yes.
Yeah, I see the background. So generally speaking, the state has very specific guidelines and regulations that are in place with respect to what is required of businesses when they reopen. And they vary based upon the type of business, but broadly speaking, there are protections for employees that are spelled out quite specifically in the state guidelines, that employers must provide guidance for employees. You have to provide, for example, social distancing markers so that everybody knows what 6 feet is in commonly used areas. You have to provide face coverings, masks, or something to that effect at no cost to the employees. You have to have some sort of protocols which involve regular cleaning and disinfecting of the premises. You also have to provide for sanitizing. Let's say at the photocopy machine or fax machine, that has to be available at the employees' desks. You have to have signage throughout the office, providing for the, or telling the employees, reminding the employees that they have to utilize proper hygiene methods, including using hand sanitizers. Implementing health screening is also important. So before they come to work, or maybe as soon as they arrive, asking questions, how are you feeling today? Or do you have a fever? Are you coughing? All of the symptoms of COVID. Have you tested positive for COVID within the past 14 days? Have you been in close contact with an individual over the past 14 days who has a COVID-related illness? And basically, you have to have a plan for cleaning in the event an employee shows up or reports having a positive case of COVID. It's very, very burdensome, to be candid with you.
Andy, with what you mentioned right now, and thank you, Amish, for that. And Andy, for what you just mentioned right now about an employee, if they show up or if they report in with COVID, what can happen with the employer? Will the employer be liable if an employee calls up and says, I got COVID, I definitely got it in your office? Is there reason for liability there for the employer to get sued from an employee and they didn't want to come in the first place?
Well, it's interesting because a lot of people are asking that question. I was at a forum with a bunch of other lawyers the other day, And the first question that arose was, how do they prove it? I mean, as a practical matter, you can get COVID from anywhere. So I could say I got COVID from this office, but how do we know you didn't get it from that poll or from this person? It's almost impossible to establish, and I'm being pragmatic here, that I got the COVID from that particular office. I'm not saying there aren't instances that arise whereby it's more than likely a person was infected because of circumstances. I have an attorney friend who unfortunately attended a meeting in Florida recently, and he and I are working on a case together. And there was one guy in attendance at that meeting that shouldn't have been there, another attorney. All 6 of them got COVID. You know, so there are instances that arise whereby an employee can establish that they got COVID on the workplace. Well, that's why there are various protections available to them. There is workers' compensation for injuries which arise in the context of your employment, which basically protect an employer from a lawsuit. So it would be very difficult to sue your employer under those circumstances. And there are protections for the employees who do become ill and required to either isolate or be quarantined.
You know, it's interesting though, because what I'm hearing, right, is that it may be difficult to prove, but it's not going to stop somebody to sue. And so there still may be litigation. Is that right, Andy?
Absolutely. We're waiting for it. You know, there hasn't been much in that regard. I mean, there have been instances whereby people are giving out waiver forms, assumption of risk. You're assuming a risk if you're getting involved with my business in some respect, you're coming into my workplace, you're a customer, whatever it may be. And there's a question as to whether or not those waivers will be enforceable in court, especially in the context of the COVID virus. So there's a lot out there. If employees do get the virus, generally speaking, they're entitled to a variety of benefits under federal and state law, and they are protected from termination for the period of time they're quarantined or isolated at home.
This is Claire. I just have a question. So when you were mentioning earlier, Andrew, about the state, I know what we found on the state was a template, basically. It's the New York State guideline template. And what we ended up doing was we have 3 offices. So we ended up filling it out for each one. Right. We have one Long Island, one Westchester, one New York City. And we've put everything in place, but because we're very concerned, obviously, about the liability piece. And I have not asked anybody to go back. We have 61 people. They're all working from home. The only thing that we've been doing is, like myself and 2 other people, my SVP of Ops and my controller, we've gone in like maybe once a week, but never on the same day, because I don't want to say we're officially open. And you know, because I'm scared to death of the liability piece of it, because even though they can't prove it, and even though we might say, well, we've done all of these things, you know, there's no way of knowing how somebody will get it. So I'm just really concerned. Do you know, I know they're talking about it right now with the new package that the Congress is thinking about liability. Do you have any sense of where that's going? On the liability piece?
I don't think it'll happen. I don't think the House will go for it. So, but let me address what you were saying. It's unfortunately our reality right now that, and this is recognized, that you could take every precaution in the world, as you indicated. And I know the form that you're referring to, that the state provides. It's very detailed, right, Claire?
Yes.
You could take all those steps and somebody can still become infected. That doesn't mean that you are negligent. In fact, I would submit that if you do everything that's on those lists, and that's a very good point, Claire, I'm glad you brought it up, because I think you have to affirm and sign off on that form that we've
right.
done all these things. Well, that's a defense. And therefore, it could never be asserted that you were negligent. You know, there may be an attempt to get around these protections that employers have if there's an assertion that an employer was grossly negligent, like just did absolutely nothing. And maybe under those circumstances, the employer could be subject to a lawsuit, which would still be very difficult. But if you follow the protocol set forth by the state very vigorously, quite vigorously, I would submit that's a complete defense. And nobody is saying, the state, Dr. Fauci, whomever, that by doing all this, you can guarantee the well-being of an employee. It is simply impossible. What you're doing is reducing the risks, and that's about all you can be asked to do.
And just one last thing on that is, even though it sounds really detailed, it boils down to about 5 or 6 things, just so everybody doesn't like go, oh my goodness, you know. And even the expense part of it was not, I mean, it was masks, it was, you know, hand sanitizer, you know, just the basics. I got about 6 of those acrylic shields, so if anybody does come in, we can put them up. So it was not, believe me, we're hurting for money just like everybody, and so it was not expensive to do.
Claire, did you also post signs?
Well, we're not in there yet, but we have the signs ready to go.
Okay, that's good.
Thank you, Claire.
And they
Claire
can
is
be
the
handwritten signs. You know, it doesn't have to be
handwritten
fancy.
sign.
You can do
As long as you have a sign on the floor, right?
Yeah.
Claire, by the way, is on our board. Thank you, Claire. Claire is the CEO of the Better Business Bureau, Metro New York. Thank you. Taylor had a question. What if your spouse or your child is high risk and they're compromised? And they have a compromised immune system. What are the employees' right to request accommodations to telecommute because they're nervous that they don't want to bring something home to their family?
Unfortunately, from what I've seen so far, that person has no right to refuse to come to work. This is a real mess. It's a very, very difficult situation. And that, going back to what we were discussing earlier, the smart thing to do would be to try to, you should be flexible. You should try to work with the employee and see if you can come up with some sort of a compromise. And you know what? It isn't beyond the pale that somebody would sue down the road by reason of those circumstances. And do you want to open yourself up to that kind of litigation, to that kind of negative press and exposure? You know, so as a practical matter, I would submit that it's best to try to work it out. But who knows what might happen if you become really stuck on having them come into work and they expose their family to it, especially when you're talking about people with an immune system that's compromised and they're vulnerable and they're high risk. But, you know, you can take a simple situation, Holly. An employee has to go to work and they're married to somebody who's over 65. They're deemed to be high risk. I don't want to come to work. My husband, I'm just using that by way of example.
Of course, but that's exactly why I married a younger man.
Smart move for a variety of reasons. But the bottom line is, if he was 68 and you said, I don't want to go to work because I got a guy that's a high risk individual at home, sorry, that's not a defense. And by the way, the guy or gal that's 68 that says, I don't want to come to work because I'm a high risk individual, I should be accommodated, is not entitled to an accommodation as per the recent EEOC guidelines. That surprised me, but that's what the EEOC has said.
Wow.
Yeah.
So Alan Kantorowicz, thank you. Alan Kantorowicz, do you want to unmute and ask your question? I see you put a question in the chat.
Yeah, I'm just curious, how long in the state of New York can you be furloughed as opposed to being fired?
Furloughed, fired, as far as I'm concerned, it's the same thing. If you're telling that person not to come, well, first of all, you're talking about a situation whereby your office is not open, correct?
Correct.
So, and the people aren't working from home, is that correct?
Correct.
So under those circumstances, they should apply for unemployment insurance.
It has nothing to do with unemployment. So the
Okay.
ownership had put in everyone's contract that they have to give 3 weeks notice, and that he would pay 3 weeks notice, if 3 weeks salary, if he terminated you. So he's never going to terminate any of us, because as long as we're furloughed, he doesn't have to do that.
That's semantics.
Well, is there a law in New York that says, you cannot, you can only be furloughed for a certain period of time?
No, you've been terminated. If he or she says, stay home, we're closed, that's it.
But there's a
Respectful.
difference, Andrew. There was a difference because we looked into that. And it's difference for me between furlough and fire was that if I furloughed someone, I could continue giving them benefits. If I fired somebody, you can't. And I was interested, I didn't furlough anybody, I didn't have to. But I think there is a difference.
But there is no specific rule in place in terms of the duration of a furlough. Let me ask you this, Claire. When you were doing your research, and this has arisen before, so Alan, that's a good question. When you did your research, did you discover anything or see anything that talked about the duration of a quote furlough?
No.
No. So let's say, so what would be a reasonable period? A week, a month, a year?
That's what I'm asking you.
Yeah, well, I would take the position, and that might be, Claire, something that's available in the context of health insurance. But generally speaking, if you're told not to come to work, we're closed, I would submit that's just pure semantics at that point.
Couldn't he, what's the word I'm looking for? Dispute the firing or something?
Well, I'm ready, willing, and able to work. My employer's saying to me, don't come into work. I'm telling you as the employer, I don't know when you'll return. So what are you? Respectfully, I just admit that's semantics, honestly.
So what do you believe furlough means?
It's basically well, firstly, it's up to every employee, and there's no specific legal meaning attached to it. It's up to every employer. Every employer comes up with a different context by which they, quote, furlough employees. So, for example, we have you on standby. We may bring you back, but we're not sure when. But you're not working, you're not getting paid, maybe in the context of health insurance, which is something I would look into a little bit more closely, you might be entitled to continue to receive coverage because technically you weren't fired. But I would ask you this. So I'm on furlough. If I'm on furlough, under these circumstances, as we described, am I entitled to unemployment insurance?
Yes.
Right.
Okay, so I'm going to ask Alan and Claire I'm going to give you Andy's phone number so that we can go back and forth with this particular issue.
Yeah.
This
Shoot
is
me
a
an
big
email.
one.
Shoot
Shoot
me
him
an
I'm
email.
going to give you an email.
Yeah,
This is a big issue to us,
Yeah.
Andy, in our community of NYSAE, because sure, we're mostly made up of association executives, but many of our partner members are from the hotel and hospitality community that have been furloughed. So while there are employers that are certainly considering furloughing employees, it's really hitting more the hotel and hospitality industry more than anything. And that, I think, is where Alan's coming from. Claire, a little different. But that whole piece about furlough, yes, I'm going to give everybody your email on that, and we can continue to do it. I mean, at the end of the day, I always say anyone can sue for anything, right?
Right.
If you want to get into litigation, get into litigation. Every employer does not want to get into litigation. They don't want to. So I love Andy's response when he says conflict, resolution. Let's try to, make things work out.
Oh, that's
Right?
100%. That's the first thing you try to do, because the only person that profits from the lawsuit is, guess who? Lawyers. And all it does is produce a lot of ill will, angst, anger. What I counsel is do everything possible to avoid a courtroom.
Exactly. So one of the questions that came in advance, I think you started to mention before, but it was about childcare. Okay, right now camps aren't there, but let's just say we were in the fall and school hasn't reopened, even though we don't even really know. Some schools, even my daughter's college, said we're opening, and then they said they're not opening, right? So, what's going to happen when school doesn't open up and moms say to their employees, I have to stay home? Again, I think it goes on to that rule, what you said before, too bad,
Well,
but really, what is it?
perhaps, but there was an interesting ruling just a couple of weeks ago or so from the United States Department of Labor. And let me back up. There's a federal law, and I wrote it down because I never remember the full name. Families First Coronavirus Response Act, which applies to private employers with less than 500 employees. So I'm sure it applies to a bunch of people out there. And it protects employees who are quarantined at home by reason of COVID. They receive 2 weeks of sick pay as long as they're not working from home. But and also they're entitled to paid sick leave up to certain caps. But more specifically, with respect to what you were asking me, it also provides for payment of salary at 2/3 the regular rate for employees who must stay home because the school or child care program is closed for COVID-related reasons. And those parents can stay out, in addition to the 2 weeks that are afforded to them automatically, an additional 10 weeks for a total of 12 weeks to take care of the kids because their school or program is closed. However, the USDOL just said this applies to camps, day camps, and summer programs. They fall into the same category. So parents who have to stay home over the summer by reason of the fact that the day camp or summer program is closed for COVID-related reasons can apply for this additional 12 weeks of benefits and protection under the law.
I like that.
The parents would have to demonstrate that the kid was enrolled or registered in a program. So, for example, a contract. If the parent could show a contract for the camp, this kid was registered to attend the camp that summer. Or there's, excuse me, a history of the child attending that camp every summer, that would be sufficient evidence of the fact that the child would have been in that camp or program, and thus the employee is entitled to that type of benefit, the 12 weeks of coverage. But employers with less than 50 employees can seek to be exempt from that extended coverage if this would cause a tremendous economic hardship to them. So that benefit is available, and it covers summer day camp and daycare programs. In addition, there's the New York State Paid Family Leave Law. Sorry, I'm just going to take a drink. Pardon me.
Yeah, and then after Sheila has a good question too about children. I want Sheila to go next.
Yeah, the New York State Paid Family Leave Law, which ordinarily doesn't apply to your own illnesses, but it does now in the context of the COVID crisis, also may provide for coverage of individuals, for employees, if they have to stay home because a school or program is closed for COVID-related reasons by reason of some governmental order. So there may be state benefits available as well. And during that entire period of time, the job of that individual would be protected.
Any follow-up to that, what Andy's talking about now? Otherwise, I'm going to move to Sheila, who had a question also, which was a very good question. Sheila, you're muted. There you go.
So we are working from home until September. And a lot of the staff actually have kids that are in their early 20s, mid 20s. And of course, they want to get out of the house right now. It has been stated to us that if we travel to a hotspot personally, that we have to self-quarantine for 14 days. And we've all agreed to that. It comes up, and we agreed to it. But what if the children living in those homes travel to those hotspots? Is it inappropriate to ask the question that those family members or those employees answer the same question, have your kids travel to the hotspot? And before you answer that, I just found out that one of the employees' kids was, I won't say what state it was, but now that son has COVID that went to one of those hotspots.
One of the typical questions that you're permitted to ask for purposes of screening, Sheila, is, have you been exposed to somebody that has COVID? Oh, for the past 14 days. But in terms of whether or not somebody in your household has traveled to a hotspot, which is what you're talking about, haven't seen that arise yet. I haven't seen that question fall into the category of one of the permissible questions, because merely because somebody traveled to a hotspot doesn't mean that they're infected. So usually it's whether or not you've been around somebody that's infected. That's what's permissible, and that's where the concern lies. And an employer can ask whether or not you have any concerns for yourself. But the reality is an employer could not specifically, I think, ask whether or not your children have traveled to hotspots. I just see that going far beyond what's permissible.
Thank you.
Thank you. Any comments about what we were just talking about? Anyone want to add? I saw in the chat box that Amish had a question again. Are you still on, Amish?
I'm here, Holly. Yeah, I mean, again, this gets back to me about this, a lot of arbitrary rules being applied, and people don't really understand this virus at the end of the day, what the implications are, how it works, and we just don't have the skill set or the medical training to be able to understand all the ins and outs. But people are coming up with the rules around this. So my question was around this 14-day number. Where does this come from? And even the hot spots that we're talking about. So if I go upstate New York, if I go to the Hamptons, and I'm in a crowd of 100 people, I don't have to quarantine. But yet if I go to, whether it's Florida, wherever it is, Mexico, I have to come back and quarantine for 14 days. To me, that just logically doesn't make any sense. So I'm just trying to wrap my head around this whole 14-day business. I get the symptoms, and if you have them, you shouldn't come in and all that stuff. But the quarantine also seems to be arbitrary at times as well.
Well, it comes from the medical professionals. They basically have stated that a 14-day period is sufficient for purposes of determining whether or not somebody is infected. If they show no symptoms after 14 days, and by the way, I'm not disagreeing with a word of what you're saying, but if they don't show any symptoms after 14 days, then they're deemed to be safe. So is it arbitrary? I guess to some extent it is, but it's the best rule of thumb that the medical professionals have come up with so far.
Thanks, Amish and Andy. Taylor had a good question. I would love her to unmute and give her question.
Hi. So I have a question. I have a colleague whose employer recently surveyed the staff about going back in the fall and how virtual learning will impact their work. And they surveyed staff asking, how will virtual learning impact your ability to work your current schedule? And if you answered likely or somewhat likely, at what percentage do you expect this to impact your work? What can employers ask questions like this, especially as things are so very, changing constantly? And also, in my personal opinion, I just don't think staff will truthfully answer whether it be they're worried they'll be let go or responsibilities will be taken from them. But I wondered your perspective on those questions.
I'm not 100% clear in terms of the Q&A that you're referring to. What type of a business is it, first of all?
It's an association.
Okay, so the question that's being posed to them is whether or not they feel that they could do their work from home, basically?
Yes, and if their child has virtual learning, what percentage will that impact their daytime hours?
Okay, well, then if you're in a situation whereby there are the federal and state laws that protect parents under various circumstances if their children must remain home by reason of COVID-related orders
Okay.
and mandates. But this is such an amorphous area right now. It's hard to say, for example, that because my child must remain home, sometimes it's a result of a governmental order, which is what the laws are saying. If there's a governmental order that requires my child to stay home for COVID-related reasons, let's say the schools are closed because of COVID concerns, then I, the parent, may be entitled to certain protections and benefits because of that circumstance.
Okay.
It's a tough situation, but the bottom line is, as I see it, those parents may be entitled to certain protections, both under the federal law that I just described, as well as under the New York State paid family leave law.
Okay. Thank you.
You're welcome.
Thank you, Taylor. Anyone else want to comment? I have other questions. Somebody wrote in and said, we have been working from home for, 5 months already. Is right? If you think about it, how can my employer tell me that now we have to come in and ask and to say that we must come in, we have to come in order to do our business when we've been working from home for 5 months? I know we've been talking about it right now already, but when I read this, I was like, well, yeah, you're right. We haven't had any problems, even when we had child care, whatever it is. I mean, we've been home for 5 months. Now they're mandating that we come in and say we must come in. Why?
That's a great question. And then that's where pragmatism should be paramount. I would submit that, hey, let's listen to our employees. You may have some people with very legitimate concerns and anxieties that can be addressed in a constructive manner. And if it's worked for so long, then why not continue it? But legally, unfortunately, those employees can be compelled to come back to work.
Yeah. And
Yeah.
another one which was similar, which is, I don't mind going back to work, but I do mind the commute. Could I ask my employer to pay for my commute? They're willing to drive in to the city. So I don't know if anybody has gotten that, but yeah, I mean, I
Okay.
don't mind coming in if I drive into the city, but don't get me on a Long Island Railroad, or, you know, I don't want to be on a subway. What do you think about that?
Same situation. The general fear and anxiety of what you would be exposed to in commutation is not does not protect you.
Yeah.
You know, bottom line. And asking for that type of accommodation that the employer pay for commutation isn't going to work, unfortunately. The only time something like that might be appropriate is if you have an individual that would be protected under the Americans with Disabilities Act. So, for example, that person is willing to come to work, but because they have a compromised a compromised immune system because of a serious medical condition, that might be part of the accommodation. You want me to come to work, I'm willing to come to work, but I submit to you that taking mass transit puts me in a very high risk situation. I want to work out a compromise, but that's a very limited, narrow circumstance.
Yeah, you know, unfortunately, we're hearing a lot of that too, even at my company. Here we are 5 months into it. And Kim writes in the chat room, Kim wrote, yeah, not only that, but when we're going to go back to the office, we're not even going to have meetings. We can't gather, right? We can't have meetings. We can't have events. And by the way, those of us in the association world all here know that we typically have live events every month. We're not going to have events still. So we're going to be Zooming from our desks with our members and everything else. So you're calling us in to Zoom from our desk. We're not dropping the ball, she writes. And so why not remote?
Makes sense to me.
Well, you're not our employer, Andy, but that's a good
Yeah.
thing. But
Yeah.
actually, Andy, your office opened up, right?
I can neither admit nor deny the truth of those allegations under the circumstances. I'm invoking the Fifth Amendment. On July 6th, we reopened, yes.
Did reopen, yeah. But I have to say, I know somebody that works for Andy's office, and she told me that they're all masked. There's a lot of rules. They ask questions every morning, right, when they come in. I don't know if, I think they're taking temperature. So, you know.
We have an app, and everybody's complete the questionnaire. It's just a few questions, 3 questions before you come in. If I see I've seen people just sitting there like this, talking to one another, almost that close without masks on. I say, do us all a favor, put on the mask, protect each other. And it's like, oh, I didn't think of it. But we're constantly reminding each other. You know, it's not intended to attack individuals or make them feel uncomfortable, but really survival starts with each one of us looking out for each other. So by generating this kind of environment, we have signs all over the place. We have sanitizer all over the place. We have all kinds of partitions that have been set up. We're trying to create a safe environment. But we do have somebody that is working remote by reason of that person being specifically in a defined high risk situation.
Yeah, you know, it's interesting, you know, on the opposite end is we have somebody that during these past 5 months has been sneaking into the office. And, you know, the employers found out and said, why is this person going into the office? And I'm the one that had a call and said, why are you going into the office? And they said, I can't take it, you know, being at home anymore. I can't take it in my apartment. I want to work from the office. And if nobody's here, why can't I work from the office? So what happens, Andy, when the employer says, we're still closed and we don't want you to go into the office?
Somebody sneaking. Well, let me ask you this. If somebody is, quote, sneaking in, they're obviously not exposing anybody to an illness. But are they in violation of the orders of that company, of the the mandate of that company, yes, they could be fired.
Wow.
You know, if I tell you you can't come into the office and you sneak into the office during the period that we're shut down, let's say the employer wants to keep the place sanitized, clean, ready to reopen at the
I
appropriate
wish that's
time.
what he wanted.
Yeah, you know, but the bottom line is that's just a violation of an employer's directives, and you can be terminated.
Yeah.
You know, on the flip side, I've seen situations where a person is permitted to work from home because of a serious medical condition, and they don't sneak, but they come in at night to pick up files or whatever they may need because they feel that's a less risky situation for them, so that they are less likely to contract the virus since they're not around other people. And that would probably be okay.
Yeah. It's interesting, you know, and again, what you said at the beginning was true, which is this is a mess. Let's work with our employees. Let's, you know, that's really what it's about. So when we did find out that this person was going in and wants to go in, we put him to work. He's now has to take the mail off the floor. He has to send the package to our Atlanta office, you know, so, and he's very happy to do so. And he, you know, so that's what's happening, you know, and some people, by the way, though, the problem with it is some people are saying, I'm not him. I don't want to go to work. He wants to go to work, you know, so that's causing the conflict a little bit
Yeah.
there. You got
Yeah,
an
it-
employee.
It is a mess.
Claire.
Yeah, and this is the short versus long-term view. I mean, in the short term, while this is going on pre-vaccine, let's say, let's hope there is one, we're doing the same thing. The only thing that we've said is, you know, we've asked our employees, same thing, who has even the slightest interest in going in. What I've said to everybody is you can't just wake up one morning and say, I want to go in. You have to coordinate it with our SVP of operations. So that way we know we're not officially open, but like you said, Andrew, sometimes you have to run in, like we're in the middle of an audit. There are some things that we need that are in the office, so the controller needs to go in and get them. And he did that for the first time since March, the other day. But we coordinated so that we wouldn't all be running into each other on the same day, even if we have all those things in place. So I'm looking at it short-term versus long-term. In the short term, everything everyone has said, you know, I don't want somebody going in if they don't need to. If somebody does need to go in, then they can identify with us how frequently they would need to do that. Or if they, like you said, Holly, I do have a couple people who really, they can't stand being at home anymore. And in that case, we will accommodate and figure out what they're going to do and for how many hours, et cetera. Because even going into the city, depending where you are, you might be able to use transit. It's such low ridership right now and not feel that kind of fear. But long term, once, you know, keep in mind, all of us are paying exorbitant rents. I mean, I have an office I'm paying for, nobody's in it. And, you know, everybody has different landlords, some better than others. But that keeps piling up, paying for all that rent where you're not in it. So longer term, the kind of business that you're in, we're associations, we're based on relationships, we're based on community engagement. Well, community engagement is not just virtual, it's also in person. So longer term, I know that we will be back in the office, maybe not 100%, maybe we'll have a hybrid system, you know, to allow for more work from home. Maybe I can cut down on my footprint, you know, as far as real estate, who knows? But you have to keep short-term, long-term in mind for those employees and try to work with them.
And you can stagger scheduling,
Right.
you know, so not everybody's present at one time, which I imagine that's something that you might consider.
Absolutely.
Thank you, Claire. And we're almost getting up to the hour here. It's about 5 to 11. So Andy, any last minute words of advice for us?
Yeah, I mean, given what we've seen here, putting aside all the legalisms and all the laws and all the regulations, the bottom line is be flexible. A lot of flexibility will allow you to remain effective and hopefully profitable. And more importantly, perhaps, will help you maintain morale and will create a lot of goodwill with your employees going forward if you show a certain amount of sensitivity and flexibility, which in the long run is to everybody's benefit.
Thank
That's
you,
what
Andy.
I would write.
So join me in a round of applause for Andy Kimler, our subject matter expert from today, from Vishnik McGovern Malizio. We really appreciate all of your legal counsel. We know it was not, professional legal counsel. We're not your clients, but I know a few of us, like Alan, may be calling you. But we appreciate you.
My pleasure.
It's so interesting. I think in the survey that'll go out afterwards, I'd love to know when everybody is planning on opening up. I heard a little bit about September, a little bit about hybrid. So curious when we are opening up. I know my office has continued to tell us we're not opening up maybe until September now. And yeah, for 5 months, we've been able to make it through. So thank you, Andy. I just want to tell everybody what's coming up. I'm sharing my screen now with the website so you can see that next Friday in our engagement lounge, we're going to be talking about diversity, equity, and inclusion action plans. I think it's been about 2 months now since we put position statements out, and we want our members to start sharing what they've done since then. We're hoping to see task force and action plans and policies and procedures. And then in the engagement lounge, we're going to be collaborating with PCMA New York. We're going to be talking about the future of association meetings. We have an Exec Connect event coming up on August 13th. And that is for the CEOs of associations, leading change, stabilizing and growing in uncertain time. There'll actually be a panel of CEOs for that one. And then on August 20th, I don't know if you remember, but in May, we were supposed to have our Synergy Awards luncheon at the Harvard Club. We actually sold out. We were in the middle of expanding the room and making it larger when our world collided. And so now it's going to be a virtual event, August 20th. I want you to please mark your calendar and be there. We have 11 amazing honorees. We have 11 presenters. We have a tremendous amount of partners and sponsors. So Synergy Awards, August 20th. Please mark your calendar. I wanted to say thank you to Judy Guys and Jennifer Ian, who's in the room. Jennifer, I don't know if you're still in there, or Judy, if you want to unmute, tell everybody that you are on the Membership Engagement Committee and why that is so important. Judy, are you able to, or Jennifer? If not, I'm going to tell them that, membership at NYSE starts July 1. It ends June 30th. So hopefully those of you that are members, you've already gotten a little notice about renewing. I hope that you renew. I hope we've been relevant and we've been able to support you through this pandemic. And we hope that those of you that have not joined yet will consider to do so. And we welcome you. And I want to thank Andy again and his colleagues from VMM. And we want you to have a great weekend. So thank you.
Thank you, and
Thank you.
stay safe all.
Thanks, Judy.
Everyone.
Thank you, Andy.
Bye-bye.
Thank you, everybody, for being here. Stay safe. Thank you.
Thank you.